This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we are going to speak about the duties owed by an adjuster to the insured and why an independent adjuster actually owes no duty to an insured unless he or she commits absolute and actual fraud. Defendant Applied Building Sciences, Inc. moved the United States District Court to dismiss claims of negligence, intentional misrepresentation, and conspiracy brought by Plaintiff Hermes Health Alliance, LLC. In the case entitled Hermes Health versus certain underwriters at Lloyd's et al., the United States District Court for the Eastern District of Louisiana on September 25, 2024, resolved the dispute. Although a landlord-tenant dispute between St. Luke No. 2 LLC and Hermes in the aftermath of Hurricane Ida started this lawsuit, the case really deals with the obligation of insurance adjusters and their vendors to the insured. Hermes owned the property located at 4201 Woodland Drive in New Orleans, on which St. Luke operates its nursing facility. After Hurricane Ida, Hermes filed a third-party demand against the insurers and others, arguing that it could not afford to repair the property because its insurance claims were denied, including a claim against Applied, a third-party engineering firm that had been hired to investigate and report on the cause and extent of damage to Hermes' property, and Sedgwick Claims Management Services, Inc., a third-party insurance adjusting company. Hermes claimed Applied's report intentionally or negligently misrepresented the cause of damage to Hermes' property occasioned by Hurricane Ida. Hermes argued that after the storm it provided Sedgwick with photographs showing the damage caused by the storm. Hermes claimed that the photographs showed evidence of unprecedented and wide-scale water damage, water driven through storm-created penetrations by wind in numerous windows, walls, and the building envelope. According to Hermes, Applied's report discounted the Category 4 hurricane conclusions as the primary cause of the windspread damage throughout Hermes' property and generally blamed the damages on the age of the roof and lack of maintenance to the HVAC and plumbing systems. Hermes argued that Applied's report intentionally or negligently ignored the best evidence of the cause and extent of damages available. Hermes also alleged that Sedgwick and Applied colluded and engaged in a civil conspiracy to deprive Hermes of insurance benefits and that Sedgwick colluded to exclude the best evidence available. Hermes further claimed that Applied clearly acted in bad faith with the intent to deprive Hermes of the insurance benefits for which Hermes was entitled. Applied moved to dismiss Hermes' claims, arguing that Louisiana law limits or bars recovery against third-party adjusters, like Applied, who assist insurers in processing and handling insurance claims. Applied also argued that to the extent Hermes intended to allege fraud, Hermes has not pled a fraud claim. The court, analyzing the issues, concluded that Applied's motion to dismiss had merit. First, with respect to Hermes' negligence claim, Applied argued that absent fraud, an insurance adjuster generally owes no duty to an insured in adjusting a claim, and without a duty there can be no negligence action. Even when an adjuster's investigation is substandard, the independent adjuster owes no duty to an insured to conduct a proper investigation. And if no duty to the insured is imputed on an insurance adjuster like Sedgwick, it stands to reason that no duty is extended to a party retained by the insurance adjuster like Applied. Because Applied was an agent of the insurance adjuster, Applied owed Hermes no duty in the absence of fraud or misrepresentation. Accordingly, the United States District Court found that Hermes' negligence claim against Applied failed. To allow an allegation that an adjuster conspired with the insurer to avoid paying the claim would be contrary to the statutory and case law limitations on suits against adjusters. Defendant Applied's motion to dismiss plaintiff's claims with prejudice pursuant to Federal Rule of Civil Procedure 12b-6 was granted. In my opinion, insurance adjusters' duties are only to the insurer that hired them to perform a service. Since there was no contract between the adjuster and the insured, there is no duty of care owed to the insured. The insured may have a right against the insurer, but not against the adjuster or vendors retained by the adjuster to assist in its investigation. The plaintiff had a cause of action against its insurer, but could never state a cause of action against the adjusters, just to complicate the litigation or try to avoid federal jurisdiction. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog and you'll receive notice of every blog posting, usually 5, sometimes 6 a week. And you'll also gain access to the more than 4,900 blog postings. You can also subscribe to these videos, which are free on rumble.com or youtube.com. And if you view these videos, I'd appreciate it if you click on the like button on YouTube and the thumbs up button on rumble.com. Please tell your friends and colleagues about this blog and the videos so that they too can subscribe. And if you're interested in further detail about insurance, insurance claims, insurance fraud, and insurance law, please consider for a very small fee subscribing to my Substack publication. Thank you for your attention.